Good afternoon, folks. I'm just going to give people a couple more minutes to join us. Welcome.
Thank you. Good to see you, Donna.
You too, Senator Rosen.
Hey, Foster, it's Tina.
Hey, how you doing, Tina?
We just got the order. We're going to have an evidentiary hearing on the Pete Sears stuff and what else? The actual innocence stuff.
Okay.
So good news. We just need to talk about it and schedule it. It was a big order, so we'll talk soon, okay?
Okay, very good.
Yeah.
Thank you.
Yeah, of course.
So good afternoon, everyone. It's 1 minute past 1, and I noticed that our squares have gotten really small and we've got 2 pages. So I think we have most of the people. There may be others who join us. But I did want to try to get started on time since it is such a big group and we have a lot on our agenda this afternoon. So we're going to go ahead and get started. Peggy or Jane, are we all set as far as our YouTube streaming?
Yes, it looks like the streaming is live, so I think you're ready to go.
Okay, thank you. So good afternoon. This is the Criminal Records Review Committee, and we're going to go ahead and get started and do introductions. And for this, I would ask people if you would obviously say your name, what group or organization you are representing on this committee, and in 1 or 2 words or a brief sentence, if you could just say what you believe is the primary purpose of public access to criminal records. Obviously, there's lots of purposes. I just want to know what you think is the primary first number 1. Because there are so many of you and boxes keep changing and shrinking, I am just going to call people by the list of members that I have. And when I call your name, if you could unmute yourself, and obviously if they're not here, we'll just skip over them. So the first member I have on my list is Senator Kimberly Rosen.
Thank you, Senator Bailey. I'm Kimberly Rosen, Senate District 8. My district goes from Castine all the way through to Lincoln, including the city of Brewer. And as former chair of Criminal Justice and Public Safety, I'm very eager to listen because I've been through a lot of this. Thank you.
Thank you. And then we have Representative Pickett.
Thank you, Madam Chair. My name is Richard Pickett. I represent District 116. Those are the towns of Canton, Dixfield, Hartford, Mexico, and Peru. I am the Republican lead on the Criminal Justice Committee. In regards to the statement you wanted us to make, I believe criminal records are extremely important for a lot of things, but the thing that really comes to mind to me the most is to be fair and equitable in employment for people who have a record and are trying to get themselves back in the workforce and back being able to take care of their families. That if we can do something there that's going to help that to me a little bit easier transition, I think that's what part of our focus should be. Thank you.
Thank you. And then from the Attorney General's office, Laura Ustak.
Hello, my name is Laura Ustak. I'm representing the Attorney General. When you say public access to criminal history, I'm making the assumption, and this may not be accurate, but I'm making the assumption that you're only talking about convictions at this point, because the public does not have access to most criminal history. And on the assumption that you're only talking about convictions, I have I guess a twofold response. One is notice and two is transparency. Notice to, well, many people and for many purposes, and that will depend on the purpose for which it's being sought, and that's what I expect we'll be talking about. And transparency, because that's important for people to know how the government is functioning.
Thank you. And then we have John Feeney.
Hi, good afternoon. My name is John Feeney. I'm the Chief Operating Officer at the Office of Child and Family Services in the Department of Health and Human Services. As it pertains to your question, looking through the lens of child safety, I think I would like to characterize it as thoroughness, trying to be as thorough as possible in our assessments when it comes to taking a look at, risk factors for children and the people that we support.
Thank you. Matthew Ruel.
Hey, good afternoon. My name is Matt Ruel. I'm the director of SBI. And so I'm actually the one that's dealing with collecting and disseminating most of these records. And I think I'll probably answer your question when I do my presentation in a little bit, if that works.
Right, thank you. Scott Landry.
Hi, good afternoon. Yes, my name is Scott Landry. I am an associate commissioner representing the Department of Corrections. I think just thinking about the question, I think safety should be really the primary root need for criminal record access requests. Really comes down to what people determine is an appropriate need for those records and under what circumstances.
Thank you. And then from the Maine Prosecutors Association, we believe we have Marianne Lynch. Is that correct? Or is there someone else from the Maine Prosecutors Association? Okay, I'm not seeing anybody. So we'll move on to Tina Neto.
Good afternoon, everyone. I am the executive director of the Maine Association of Criminal Defense Lawyers, stepping in for Matthew Morgan, who will be on this committee moving forward to answer Senator Bailey's question. I think we're all more than the worst thing we've ever done, and we should be allowed to move on from past mistakes, especially when they are very far in the past, and let people live a full and complete and shackle-free life.
Thank you. Sheriff Robert Young.
Yes, good afternoon. I'm the sheriff of Piscataquis County. When in this particular area, I think of two things: public safety and government accountability. Thank you.
Thank you. Chief Jared Mills.
Hi, everybody. Jared Mills, the Chief of Police here in the city of Augusta, and also the main Chiefs of Police representative on this panel. Along the lines of what the sheriff said, safety, balancing that with transparency, as well as the rights of the folks who've been convicted to be able to move forward with a productive life.
Thank you. Representative Harnett.
Thank you, Chair Bailey. My name is Tom Harnett. I represent House District 83, which is Gardner and Farmingdale. I serve as the House Chair of Judiciary and the Chair of the Right to Know Advisory Committee. And what I want to balance on this committee is public safety, but not perpetual punishment.
Thank you. Foster Bates.
Hi, good afternoon, everybody. My name is Foster Bates from the Maine State Prison and NAACP President. And I believe that the access to public safety should be, first and foremost, public safety driven, as well as giving those people who are released from facilities throughout the state an opportunity to reintegrate back to society with a fair opportunity at jobs and employment. To restrict that, I think that is fair and unreasonable.
Thank you. And Barbara Taylor.
Hello, I'm Barbara Taylor. I've been for the last 16 years a staff attorney at Immigrant Legal Advocacy Project with a specialty in the interaction of criminal and immigration laws. That's going to probably color the lens through which I see this, the tasks of this committee. I will be especially interested in making sure we maintain access for people to their own records, because as you may or may not know, under immigration law, nothing ever disappears, nothing ever doesn't need to be brought up again.
Thank you. Frank D'Alessandro.
Frank D'Alessandro, I work at Maine Equal Justice. Our concern here is the collateral impact of convictions on individuals' right to get basic necessities such as housing and employment. And we're very concerned that often it seems like these collateral consequences are more punitive than the actual sentence.
Thank you. Andrea Mancuso.
I think Andrea had to step away for just a minute, but she will be back.
All right, thank you. Courtney Allen.
Thank you, Senator Bailey. My name is Courtney Allen. I'm the policy director for the Maine Recovery Advocacy Project. And for me, I agree with Representative Pickett that the primary role and hope for me is that when somebody's criminal charges and sentences end, that they will be able to access employment.
Thank you. Peter Lehman.
Afternoon, my name is Peter Lehman. I'm here representing the Maine Prisoner Advocacy Coalition. I'm also the vice chair of the Maine Prisoner Reentry Network. I think that the main purpose currently of making criminal records public is to make people feel good without necessarily accomplishing anything.
Samantha Hogan.
Hi, everyone. I'm Samantha Hogan. I'm a reporter with the Maine Monitor, and I'm representing the Maine Press Association. And when I think about criminal records, or really any records, it's about being able to inform the public about the actions of their government so that they can make informed decisions.
Marissa Bodner.
Hi there, I'm Marissa Bodner. I am an anchor and also an investigative reporter with Channel 13 down in Portland. I'm here to represent the broadcast interests. And when I think about the purpose of public access to criminal records, a few of the words that come to mind are transparency, accountability, and also public safety.
Thank you. Elizabeth Ward Saxel.
Hello, Elizabeth Ward Saxon with the Maine Coalition Against Sexual Assault. And let's see, I think I come at it from the what ideally they should be about, which is narrowly and with context contributing to public safety.
Thank you. Emma Hallis O'Connor.
Hello, I'm Emma Hallis O'Connor. I'm an attorney at Pine Tree Legal Assistance. I work in the area of housing. So similar to others, I come at this thinking about access, especially to basic needs like having a roof over your head, and how a criminal record following you can add to the already compounding barriers to housing and employment, but also the need for very, very tailored access that really gets at true public safety needs.
Hannah Longley.
My name is Hannah Longley. I am the Director of Community Programs with NAMI Maine. And when I think about the purpose of access, I'm going to go with Elizabeth and kind of ideally what I would like to see is, thinking of the statistics of ensuring that we're protecting the safety of those that are most vulnerable and of the public, but also ensuring that we're not entrenching or stigmatizing individuals who have been involved in the criminal justice system.
Megan Sway.
Good afternoon. My name is Megan Sway. I'm Policy Director at the ACLU of Maine. I'm here standing in for my colleague Michael, who's not feeling well today. From our perspective at the ACLU criminal records, there's both a public's right to know, balanced with personal privacy of people, and the ability to move on after someone has been sentenced, to find employment, housing, education, all of that.
Dee Clark. Is Dee Clark here?
Sorry, I forgot to turn on my microphone. I'm Dee Clark with Survivors Speak USA. And this is a hard question because I don't think anyone should see anybody's criminal record. But since we're answering it, I would say that it should dissipate. It should be leaving as the person's doing their time. So by the end of their time, there is no criminal record.
Thank you. Jill Ward.
Good afternoon, everyone. I'm Jill Ward. I'm Director of the Maine Center for Juvenile Policy and Law at the Cumberland Legal Aid Clinic at the Law School. And I come at this question from a perspective of the purposes of the Juvenile Code and adolescent development, and what that means as you apply it to young adults, as far as public access and the goals of trying to allow young people to move on with their lives while also being aware of the general public safety concerns.
Judith Meyer.
Thank you, Senator Bailey. My name's Judy Meyer. I'm the editor of the Sun Journal in Lewiston, the Kennebec Journal, and the Morning Sentinel, and I'm on the board of the Maine Freedom of Information Coalition, and I'm on this panel representing the MFOIC, which is a group of librarians, journalists, archivists, and others who we consider friends of FOA. And to answer the question, I think access to criminal records serves accountability for the prosecutorial process and full transparency into a system that places Mainers in jail. And I think it's important the public is aware of that process and understands how it works. Thank you.
And the Honorable Brent Davis.
Good afternoon. Good afternoon. My name is Brent Davis. I'm a judge sitting in Augusta, Waterville, and Skowhegan. And when I think of public records, I think of information and public safety.
Thank you. And I'm just going to go back and see if anyone is here from the Maine Prosecutors Association. Okay. And is Andrea Mancuso back?
Hi, Senator.
Yes,
Sorry all for being absent. I'm Andrea Mancuso. I'm the Public Policy Director with the Maine Coalition to End Domestic Violence.
And Andrea, since you weren't here, we are answering the question in 1 or 2 words or a short sentence. What is the primary purpose of public access to criminal records?
Well, I think from my lens, we see some of that linked to safety and transparency around that. And to some extent, there's a level of accountability.
Thank you. And then my esteemed co-chair, Representative Talbot Ross.
Thank you, Madam Chair. Welcome to everyone. Rachel Talbot Ross. I think my colleague and good friend, Representative Tom Harnett, said it best, a balance between public safety and not perpetual punishment. Thank you.
Thank you. And I am Senator Donna Bailey. I represent District 31, which is Saco, Old Orchard Beach, Hollis, Leamington, and part of Buxton. And my response to what is the primary purpose of public access to criminal records is public shaming. Think Hester Prynne and the Scarlet Letter. So thank you all for your responses. And I think it kind of sets the tone for the work we have to do here, and a lot of different interests to balance, as shown by the fact that we have 29 members on this committee. But I think we can do it with the help of, and this will be transitioning to the next item on our agenda, our wonderful staff helping us from OPLA, Peggy Wrench and Jane Oberton. And actually going to turn it over to Jane, who is going to just do a quick overview of this incredible resource book that they put together for us. So if Jane, if you could just give us an overview and kind of let committee members know what is in this wonderful notebook.
Thank you. I'm having an audio problem. Can you hear me?
Yes.
I'm having a terrible feedback problem that I'm going to have to step away and fix it. So if you could just pass me to the end of the agenda, that would be great.
Okay. All right. Well, I hope you get things fixed.
Thank you.
So then moving on to the next item of our agenda, actually my co-chair, Representative Talbot Ross, is going to lead that discussion. So to you, Representative Talbot Ross.
Well, thank you, Madam Chair. I did notice that DA Sarbach just joined us. I'm not sure if he could take just a moment to introduce himself. I'm sure he's here perhaps on behalf of the Maine Prosecutors Association. But I do want to give DA Sarbach the opportunity to introduce himself and perhaps give us an answer to the question that we've all asked, which is in introducing ourselves, Jonathan, we answered the question, what is the primary purpose of public access to criminal records? So Jonathan, are you here? Do you want to introduce yourself?
Yes, good afternoon, Representative Talbot Ross. And thank you very much for having us. I apologize. There was, I guess, some confusion on somebody from the MPA representing, and my court schedule was cleared today, so I was available. Again, for people who don't know me, I'm Jonathan Sarbach. I'm the district attorney in Cumberland County. I think, Representative, to answer your question, one of the reasons I believe for a criminal record would be for law enforcement and prosecutors and ultimately the court to have a representation of a person's involvement with the criminal justice system, to know at what times and at what areas of that person's life was somebody arrested, and ultimately if they did receive a disposition in the court system, and for what. I think would probably be the quickest way for me to sort of get into those cases, or to get into the answer to your question, because ultimately when a case comes to a prosecutor, we basically only have a police report, any evidence, and then ultimately a criminal history if a person has one. And that allows us to try to make a recommendation to the court with regards to what the DA or the prosecutor would think would be a just disposition in the case.
Oh, right, so-
Thank you very much, District Attorney Sarbuck, for joining us today and for your answer. Because Jane was not able to get to walk us through the binder, I first want to make sure that everyone received a binder and has all the information they need for today's meeting. And if you do not, if you could somehow raise your hand or get in touch with Jane and or Peggy. I'm not sure if on this recorded Zoom you're able to access a chat, but if you do not have that binder, it would be really important for us to know. So I will call your attention to getting in touch with the staff in order to get that information. I also want to just, before I start and talk about the bill that brings us all here together, the law that brings us all here together, I want to point out the historical significance of having Foster Bates join us in this process. Foster Bates is a resident at Maine State Prison. He is the president of the NAACP Prison Branch chapter. And this is historic because we have a currently incarcerated individual who's participating in a legislative process of thinking about the best public policy and lawmaking that can take place. And so I want to honor his participation today, and I want to thank the presiding officers for their wisdom in making sure that someone who is currently living with this experience can best inform the process. So welcome, Foster Bates. I also wanted to call attention to the historical context of this bill. This is the second iteration of this committee, of this Criminal Records Review Committee. Many of you participated in the first iteration of this committee and know that we were able to get only so far with the limited amount of time that we were allowed to look at this. So I want to thank you to those who have participated in the past for joining us again for this particular process. It is our third attempt, however, to look holistically at criminal records and their purpose. So I also want to just acknowledge each and every one of you, if you're here for the first time, for your commitment in looking at this as a very critical aspect, as my colleague Representative Pickett said, in order to ensure that those who have paid their debt to society are able to move on with their lives. So thank you for your commitment to that. This particular resolve, and you should have it in your binder, you can reference it in your binder, is, as Madam Chair, Senator Bailey pointed out, we are a 29-member committee. 29-member committee. And I want to thank Representative Harnett and the Judiciary Committee for their wisdom in passing this bill, getting this bill out of committee with 29 members, because that in some regards can stop a bill from moving forward. But I want to thank them in their wisdom for making sure that all stakeholders had a voice at this particular table. As you will see from the bill itself, we have quite a bit of work to do. Section 5 of the bill articulates 9 different duties and responsibilities. It is not, one of them would be enough, but we are taking on, I dare say, the whole system of adult convictions. We have those, as Jill Ward has pointed out, who represent our juvenile criminal legal system, as well as the district attorney. But for the most part, I think, and it's a decision we have to make, that this is applicable to an adult criminal legal system. You'll see that it incorporates us taking a look at what's happening nationally, and that is in the tab 3, what's happening nationally. It looks at clean slate, that is tab 4, and other tabs, but it is quite a lot to get to in the next couple of weeks. I will also say that we have, it says no later than December 3rd, that we have a report due back to the Committee of Jurisdiction, which would be Judiciary. One of the things that we need to do today is to decide if we will ask for an extension of the Legislative Council to extend our meetings by one meeting. You're only allowed one additional meeting, and that would be on December 15th. So that's one of the things we will need to approve today. Any questions about the law itself, the resolve itself? So seeing none, we'll go right into, if that's okay, Madam Chair, we'll go right into looking at expectations for this meeting and expectations by December 15th. So the expectations for today's meeting really are, again, to approve the request for an extension to Ledge Council to December 15th. We do need to decide how we're going to structure our work. So the format for us doing this work, it will be difficult to manage 29 people in total conversation for the length of the time we're together. So we need to make a decision about a possible subcommittee work with the 3 meetings that we have remaining, or 4 meetings we have remaining. We do need to also, after today's presentation, make a decision about any other presentations to this full body. If there's more information than we need, if there are other voices and other aspects of our work, if we want to invite additional presentations. So that's the expectation for today, that we will reach conclusion on those 3 things. In terms of expectation to achieve by December 15th, of course, that is the big report that's due. It should include recommendations and possible introduction of legislation for consideration in the second regular term. As you will see in tab 2, under Maine legislation in your binders, there was quite a bit of legislation that has been put off until this committee could come together. That a lot of work, a lot of bills, a lot of passion, a lot of movement forward, hopefully, that has been delayed in order for this committee to take shape and to possibly move some of those bills forward in our legislative recommendations. Those are the recommendations for today, plus the bill. Any comments, questions? Anyone want to add anything before we move on? I'm not, yes, Dee Clark.
Just for clarity, is any of what you just said in writing today's expectations or tomorrow's expectations?
No.
Okay.
Yeah, we can certainly will be producing a set of minutes that have it on there, but no, that it is also Dee, part of the group's authority to change any of that and to add to that in real time. Thank you. I am not seeing any questions or comments, Madam Chair, so I'll turn it back over to you. Thank you.
So Representative Talbot Ross, did you want to see a show of hands on either extensions or subcommittees, or did you want to do that at the end?
That's a great question. Thank you, Madam Chair. Why don't we take a moment to do that now, just in light that not everyone may be with us at the end. So I'll ask the first question, and I guess it's just a show of hands, and maybe Peggy and Jane, if you could just take note, let me know when we've got a majority of folks who have voted to approve. I'll just move forward, I think, to approve the extension of our work for one additional meeting, which I believe would end up with a report due back to the Judiciary Committee on December 15th. And I will say all those in favor, I guess, if we're doing it. Frank, if you could either turn on your video or raise your hand. Thank you. I think we have a majority, if not unanimous vote to get an extension. The other decision, I think it will be a little bit more difficult, but nonetheless, we can attempt to do so, Madam Chair, which is to decide about breaking our work into more of a subcommittee fashion, so that any decisions, any movement forward coming out of today's meeting can be done so in a more methodical, manageable format. We can figure out what that looks like as we move forward, but is that the format? I guess all we're asking and for your vote is that the format that we would like to move forward in order to get our work done is through a subcommittee structure. All those in favor of that, just raise your hand or. Yep, a majority has agreed to that format. I dare say I will ask for any of those who are against this particular organizational structure. If you want to lower your hands. All right, I am not seeing any opposition to it. So Madam Chair, I believe we can move forward in those two regards. I will only say one additional thing before handing it over, and that is back to Dee Clark's question around expectations. The expectations around December 15th, I will add one additional expectation, which is recommendations to move forward to the legislature that will or may include even thinking about constitutional amendments. And with that, Madam Chair, I'll just hand it back over.
Thank you, Representative Talbot Ross. So yes, I would ask people to be thinking both about possible legislation, which may be what's in your binder or maybe some other possible legislation. And as Representative Talbot Ross suggested, possibly even a constitutional amendment, which I think we'll all understand what that means after today's meeting, if you don't know already. So if there are no questions thus far, we'll move on to section 3 of our agenda, which is going to include a presentation about the criminal records landscape in Maine as it currently is. And we have 2 guests who are also members of our committee. Matthew Ruel is the director of the State Bureau of Identification of the Maine Department of Public Safety, and Ann Jordan, who's a criminal process and specialty dockets manager at the Maine Judicial Branch. And they're going to just talk with us about what are criminal records, where they're kept, who keeps them, how are they used, what happens to non-criminal adjudications, non-conviction information, etc. So Matt and Ann, I don't know who's going first, but you're up.
Ann, it's up to you. Just let me know.
Is Ann with us?
Pretty sure
this is Peggy. Ann's having some trouble with Zoom. I think she's in here somewhere, but Matt, if you could go ahead and start, I think that would be great. I know that you two have kind of tag teamed this in the past, so if you could get started, that would be great.
Sure. Let me see what I can do here to get started on sharing my screen, hopefully. Can everybody see that okay?
Yes, thank you.
Okay, thank you very much. So again, my name is Matt Ruel. I'm the director of SBI. I want to thank Representative Talbot Ross for inviting me back again. I appreciate her including me in this process. Some of you have probably already seen this presentation. I know I've provided, I don't remember if it was for judiciary or for criminal justice, So it's going to go over some of the same things, but it's kind of just an overview of what we do, how we do it, and kind of how it pertains to criminal records. Some of it won't completely apply, and I'll just kind of skip over those things. But as you can see, the State Bureau of Identification, one of our main roles is dealing with being the central repository for all criminal records. So we collect, preserve, file, distribute those records, both in state and with the federal government. What information is maintained by SBI? So conviction, adjudication information, pending charges within 1 year if we've received information from prosecutors. And it's important that folks know that we have interfaces with numerous different systems. We get stuff from the criminal justice side or law enforcement side. The prosecutors have an interface with us, so we get their kind of segment of the information as well. And then we get information from the courts in terms of dispositions. And then we also receive information from Department of Corrections on a limited basis. So that's kind of all the information that we collect that makes up our criminal history record. But in general, any information that by statute is labeled criminal, any Title 12, which is fish and game, or 29A, which is motor vehicle, that involves drugs or alcohol after 9/1 of 2000, any felony Title 29A information after 9/1, felony juvenile adjudication information after 9/1 2000. Types of information are not retained by SBI. So when we talk about criminal history, that doesn't include, for my purposes, doesn't include police reports, protection from abuse orders, warrant information, civil violations, such as traffic infractions or local ordinances. We don't maintain any of that information. It doesn't come to us. We've talked about that in some of the committee sessions in the past about civil drug information. We don't have that. So we'll probably circle around on that, I'm sure, in the coming meetings. So to track all of this information, we've got to have an arrest tracking number. And basically, that's an identifier that we use throughout the criminal justice process that kind of ties all this information together. So we've got law enforcement starts a criminal proceeding. They've got information that they enter into a system. There's an arrest tracking number that's issued. That then is shared with the prosecutors to, again, link together that process. And then it follows through to the courts so that we can see every segment of the criminal justice action. When do we need ATN CTNs? If we're going to have criminal history information, again, any criminal offense, that Title 12 or 29A offenses, including or involving drugs and alcohol, the felony 29A offenses, and the juvenile information again. Skip over that. So if we don't get an ATN CTN, for our purposes, there's really no record of that incident if we don't get it. For our law enforcement purposes, obviously officer safety is an issue if we don't have criminal history that's available to law enforcement roadside. Community could be placed at risk based on how the information is used when you're talking about vulnerable populations. Criminal justice agencies and public consumers can't make sound judgments based on incomplete criminal history, and I'll get into that a little bit later on with third-party brokers of criminal justice information. Let me make my slide complete here. So again, just a graphic showing kind of how that ATN CTN ties all the pieces together. Dissemination. So when we look at dissemination of criminal history information, really we're looking at confidential criminal history and public criminal history. So SBI collects and maintains all of these criminal history records that are provided to us, but it doesn't mean that everyone gets to see it. So criminal history is not made public if there's no prosecution, if there's a non-conviction disposition, if you receive a pardon, if a year has elapsed and there's no disposition. Those are all factors that would keep that information just for law enforcement purposes. I normally have a rap sheet that I would share, and if people want to see that, if they've never really seen what's included on a rap sheet, I can send it out to the mailing list if that's something people think would be useful. So I could do that after the meeting. So another thing to keep in mind is how are the feds involved in the criminal history process? So Maine submits all of our criminal history information to the FBI for inclusion and use by law enforcement across the country. Now, the feds only accept the information if it's supported by biometric, which in this case is a fingerprint. They want to make sure they have a positive identification on an individual. So when we supply the information, it goes along with a fingerprint that's usually captured at arrest or incarceration. That information is then available for law enforcement purposes. And criminal history is accessible for licensing and certification purposes with the appropriate state legislative approval that comes out of something called Public Law 92-544, which came about, I want to say, in the 80s on the federal level, that kind of dictates how criminal history can be used for licensing and certification purposes. Prior to Public Law 92-544, it was only available to law enforcement and for law enforcement purposes. So we've got two different ways of that allows people to get access to criminal history information. One is through a name and date of birth search, and then another one is based on a biometric or a fingerprint. So everybody has access to our online service to run a name and date of birth search. We do, probably a lot of people don't know this, we do hundreds of thousands of those checks each year. People can request those from anywhere in the country. Local businesses for employment purposes are using those. Towns, county governments, numerous agencies are doing those things, and it seems to grow every year. Many of those checks are done because we don't have an approved statute that allows a fingerprint-based check, which then allows a state and federal criminal history to be provided. And generally, you'll see those checks for licensing, certification, positions of trust. To go through that process, the state needs to get a federally approved statute in place. Some examples of those licensing certification purposes are really tied to hazmat drivers, port mass transit access, federal employment, military employment, if you're in the banking industry, international travel, care of vulnerable populations, security guards, childcare. Some states have taxi drivers. There's numerous different purposes that could be approved, but Maine has a very limited number of those statutes that are approved right now. Generally, it's people always know about our teachers that are having background checks done, adoptions, foster homes. Those are the largest requesters of our criminal history. So protecting the public information. So a fingerprint-based check provides positive ID. We're routinely audited. And I'm pointing some of these things out because I know a lot of people in the past have asked questions about, how are we dealing with criminal history? How are we protecting people's information? So we're routinely audited both on the state and the federal side in our use of criminal history, how we maintain those records. There's a requirement to have an approved state statute that has a very specific purpose. As an example of that, Maine Revenue Service. There was a federal law that came about where people that were having access to Social Security numbers, tax information, had to have a state and federal background check done. So just because that federal law is passed doesn't mean that Maine Revenue Service could just get that information. So they had to go to the legislature, put a bill in, have it get approved. It became state law. I then have to take that, submit it to the FBI's legal counsel. They have to review it and make sure that it's limited in its scope. So we can't just say Maine wants to run a background check for whatever purpose. It has to be very, very specific. Then once we get that approval, then we can actually offer that service to Maine Revenue Services. So that's kind of a process that we go through that way. Maine is also a member of the National Compact Council, and that's made up of representatives from each state. Rules are set up around the governing of the use of criminal history, applicants' rights. It limits the use of dissemination and how that information can be used. The state determines if information is maintained or destroyed after a response is provided from the federal government. So we have some control over that part of the process as well. And then I'm required to make sure that applicants know that what their rights are. They have to sign a waiver allowing the check to be done in the first place, that the results will be shared with a third party, that they have a right to review and challenge inaccuracies or incomplete records. And that's also a part of the process that we go through as we're doing a fingerprint-based criminal history check. So the importance of maintaining this information, clearly when you look at criminal history, the bulk of it is really there for law enforcement purposes, but the needs of the public have really grown exponentially over the last 10 years. When I first started working at SBI 15, 16 years ago, we were probably doing a few thousand fingerprint-based checks a year. And now we're probably doing about 40,000 of them a year. It's also important to know that the state has the most complete record, and it needs to be available to the public, or decisions are made with incomplete information. And following up on that, I think it's really important that folks know that if we don't provide the information, others are going to do it on our behalf, but it'll never be as complete as our own records. Failure to provide timely, accurate, complete records negatively impacts the users, consumers, businesses. It causes an inability to get licenses and certifications in some cases. We've had impacts on reciprocity agreements for certain jobs. There's a liability aspect that plays into that. Delays in international travel, prohibits federal reimbursements in some cases. And some of those examples are really just tied to when the feds create requirements on their side, having the ability to then offer these services on the state side, or if we don't, it creates a problem for them. We had one situation where there was some federal reimbursements around childcare, and at the time we didn't have any type of a statute that approved it, so the people couldn't get reimbursed from the federal government for childcare purposes. So we run into those kinds of challenges. And you know, it's also important to note that there are, I dare say, thousands of criminal history companies out there that if you Google it, you'll find all kinds of services that are out there. And one of the biggest problems I run into and my staff run into is that we'll have somebody call in saying, this is a problem with my criminal history. Can you fix it? And we'll start to go through the process and find out that they never got the criminal history from us. They went to some third-party agent who maybe just looks at criminal history as what they find online or what they pull from the court system, which isn't the full record in many cases. They'll also sometimes just go to the largest county in a state and then pull records there and say that's the criminal history. So a lot of this really has to do with it provides an avenue that somebody can get a complete criminal history from the agency that actually maintains it all, as opposed to a third party that may not be showing you the complete record. And then another thing that we're starting to find is, having access to this criminal history information is important on the research side of things. And we can probably get into that a little bit later as we start to discuss things. So that's really the high level 50,000 foot view. I was just looking at this as kind of the foundation. I know that Ann will probably chime in with her own comments, and I'm hoping that this will then start as a process of being able to provide a good, healthy discussion on how the whole process works. Do you want, I see a hand up.
Yes, I was just going to ask if there were questions. So Representative Pickett, did you have a question?
Yes, I just wanted a request. Is there any chance we could get a copy of this slideshow for us?
Yes, sir. I can provide anything. I can probably reach out to Jane, get the list of all the members, and the same thing with if people aren't familiar with what a rap sheet looks like or criminal history summary. I can provide that information also. I'd rather throw it all out there.
Thank you, Matt.
No problem, sir.
Thank you. And yes, I think the rap sheet would be helpful just to have that reference.
Okay, I'll do that.
Thank you. Any other questions from committee members for Mr. Ruel? I'm going to scroll a little bit to hopefully not miss people.
And I'm not going anywhere. I'll be here.
Thank you. Courtney Allen, I see your hand up.
Thanks, Senator Bailey. Matt, I was wondering if you could provide the committee with a list of licensures that require background checks in the state of Maine, and if there are a list of crimes that automatically disqualify somebody for qualifying for that licensure.
Well, I can put together the list for you. I've got that, and I can get that out with the other materials. In terms of automatic disqualifiers, we're not seeing as much of that anymore. That's nothing that I would establish. If anything, they come out of the federal agencies, so that they would say, I want to say Health and Human Services at one point had put up some automatic disqualifiers, but I know there was pushback on that, and I don't know if it ever changed, but generally it comes from those, whatever the federal mandate is. We don't actually push anything out from the state side.
Thank you. If you could provide me what you
can.
Representative Talbot Ross.
Thank you, Madam Chair. Just something to note as I piggyback off of Courtney's question, and maybe you can take a look at this, Matt, is I do believe there's an automatic disqualifier for anyone who wants to get licensed and operate a cannabis entity or facility in the state of Maine. There's an automatic disqualifier. So if we can take a look into that, it might help answer Courtney's question as we continue.
And I think you could be, I'm sure you're right there, that there probably are automatic disqualifiers in the statute, but I don't have any control over what they are, or if there is one, I guess is what I was trying to say.
Okay. But Matt, would you be able to still produce a list to answer her question, even if it does not, as you say, you don't have any influence over that?
Yep, I have a list of every federally approved statute.
Okay, thanks.
I next saw Peter Lehman's hand.
Starting myself up again. Yeah, Mr. Ruel.
Sir.
Your slide was talking about the importance of maintaining criminal records. And I just wanted to clarify, that you were talking about the importance of maintaining the records, for instance, for law enforcement and the courts, not necessarily in making them public.
I think that you're correct that we are talking about a couple of different things here, and maintaining the record is kind of the starting point, and then the dissemination piece is a whole other conversation.
Okay, I just wanted to clarify that you weren't making an argument for them being public.
No, I haven't, no opinion from me yet.
Okay, thank you. The other question I had was when individuals, most of the requests for criminal background, for public criminal background, come from people who have received applications. Is that correct?
Let's make sure I understand what you're saying. Receive applications. What do you mean by that, sir?
Well, for instance, an employer or a landlord.
Well, I would say that for public criminal history checks that anybody can do, I don't know exactly what their purpose is. It's available for people to run. I know anecdotally that, yes, there are numerous agencies that are doing that as part of an employment check. And I base that on the fact that the amount of call volume that my staff will get and troubleshooting things or asking questions. But I also know that there are a lot of people that are running checks for, their child's dating somebody and maybe they want to run and see if there's a criminal history on that person or whatever other purpose they may be wanting to do it. I know that there are requests that come from other states that then cascade out across all the states. So they're just kind of triggered as part of that full process. So it could be various different reasons as to why they're running it.
So a person who was wanting to do a criminal background check would need a full legal name and a date of birth, which I would guess they asked the person, but that would mean that if I want to know the history of my boss or my teacher or my lawyer or my doctor, I would need to ask them directly for their full name and their date of birth.
Well, I think that I see where you're going with that. And yes, generally you'd probably ask for that information. I think if somebody is savvy enough, you can probably put the pieces together to get that information anyway. I'm sure if I, worked at it a little bit and wanted to run a criminal history on somebody, and I know just from Googling something that I'm sure I can find out where you live and where you work and who your family contacts are and all the other things that Google provides you nowadays.
Okay, my point is that when we're talking about, my question was, and you've confirmed it basically, that when we're talking about making these records public, we're primarily talking about people who are getting their records checked, being in a subordinate position, and that those records then benefit directly the people who they're applying to most of the time.
Sure.
Thank you, Matt.
Yep.
And now I did see John Feeney's hand raised, but did you get your question answered?
I was just going to share that there are automatic disqualifiers in childcare and also with children's residential treatment facilities and shelters. They're in our rules and they do flow down from the federal government, and I can get those over to Matt and included in the list. But I also do have a question for Matt as well. On your dissemination slide, it talked about confidential information. So when a record is restricted for dissemination and it's confidential, does only law enforcement have access to that information?
I think that typically, yes, it is only law enforcement. But I believe, and you probably know better than I do, I think there's a carve out in statute for child protection services to get access to certain information. So it really depends on what state statute allows.
Okay. All right.
Any other questions? So Matt, I had a question. If a criminal record is sealed by the court, what happens on your end and who can access that?
So if we get an order from the court saying to seal that record, then that's only available to law enforcement. It's not available to the public at that point. And we do get some of those sealed orders.
All right, thank you. And Representative Talbot Ross, did you have a question?
Yeah, thank you, Madam Chair. Matt, this latest part of the discussion, I'm wondering, and maybe Ann might have it, but I'm wondering if we can get the terminology, so sealed, vacature, expunged, confidential, all of the ways in which we describe this process of making records not available to the public. If you could put the definition of that, the name, the word, the definition, and then who has access to it, is it possible to do something like that?
I was thinking I can probably work with Opla on, I don't know if it's Jane or Peggy or whoever may be involved, but we can kind of go through that. And it's funny, great minds think alike. As I was listening to Senator Bailey, I appreciated the fact that she used the terminology of sealed, because we do go back and forth on so many times people are using sealed and expunge interchangeably, and they mean two different things. And I like to keep us on the sealed path. Expunge creates a lot of other issues for us. But yeah, I'm sure I can work with them to define those things better.
Thank you, Matt. I do think expunge is really, really important. And I do think the word vacature is important because we've had bills come before the legislature that frequently use both of those terms. And so it would be helpful to include those in what you can prepare for the committee next.
Okay.
Thanks.
And Peggy will be going over those terms later in the agenda as well, but it will be important for all committee members to be familiar with all those terms and the differences between them. Barbara Taylor, did you have a question?
I had a question for Matt. I just wonder if the subject of a record if that person has access to their own records. And I just wanted to note that the binder we have lovely definitions in the very back about the difference between sealed and expunged. And again, as an advocate for Maine immigrants, I'm going to be very concerned that we preserve the option of vacature, even for cases that are sealed or expunged, because that will often be the only immigration remedy people have. So I'm going to be looking at jurisdiction and other things to be sure we preserve that path to vacature. Thank you.
And I would just chime in on your comment that yes, people do have access to their records, and that's a key part of our challenge process as well, is that folks can end up challenging their record, and if there's discrepancies, and we can kind of research those pieces.
Thank you, Matt. And just to follow up on that, so when I asked the question about a record that had been sealed and you indicated it would only be available to law enforcement, did you mean to say law enforcement and the person, him or herself, or is a sealed record not available to the person?
Well, I guess the way the statute would be written, and I'd probably rely on maybe Laura or Ann to better answer this. I'm drawing kind of a blank, but I believe that a person would still have access to their record, and generally they would go through that as a challenge process. And an example of that would be somebody reaches out to us and says, look, there's criminal history on my rap sheet that it's not me, it's tied to somebody else. So then we establish their identity. and through a biometric, compare it to the record, and then we can go through a process with them to kind of look at that or add a notation to their record. And if it was sealed, we would still add a notation because law enforcement would need to know that information as well if there was some kind of a discrepancy that needs to be researched. So I think they would have access to all that.
All right. And is Anne back with us?
I am.
Madam Chair?
Yes.
I just wanted to make sure we saw Dee Clark had her hand raised before we transition.
All right, thank you.
I'm sorry to go back, but I thought I heard something a little while ago and I didn't respond quick enough. What was said about Child Protective Services?
I think we were talking about records that may not be confidential could be available based on state statute to or for certain purposes outside of just law enforcement. So if somebody's doing child protection work at DHHS, then I believe they have access to it. There may be another limited reason that would allow somebody to have access, but it's very, very limited and it's always by state statute.
And they're long lasting. They're not temporary.
Well, yeah, if it's a state statute and until it's repealed or sunsets or something like that, then that's what we would follow.
That does lead me, and Matt, you're not necessarily the person to ask, but just since we're having this discussion, and perhaps John Feeney can answer this question, it is interesting what Child Protective Services does with their records, in that there is a certain amount of time after which the records don't show up on a background check, but the Department of Health and Human Services always has access to those records. So, you know, they can look back and see someone's history. John, am I correct on that?
Are you talking specifically about the child protective record, whether a person's been substantiated for abuse and neglect?
Yes.
Okay. Yeah. So those records remain in our system. We do protective checks for any type of employment that involves people working with children. When those requests do come in, if it's in the system and it's a substantiation, we do share that there's a record of substantiation on the individual.
Oh, okay. So I thought there was a time period after which those don't show up on a background check, even though they're still in the system, but I'm mistaken about that.
Yes, if it's in the system and it's substantiation, then we will share that.
All right.
And I would say it doesn't show up on a background check. It would be something that's available for their purposes, right?
And they have to request it specifically and get approval to, the person has to authorize them or authorize us to release it.
Right. Thank you. Any other questions from committee members? Just taking a look here. And again, Matt, was Anne able to join us, and did she have anything to add, or?
I think I heard her on there.
This is Peggy again. Anne is having problems, but she's connected by phone, I believe, and hopefully she can hear us, so she can join in with her part of this presentation about how the courts deal with the records.
Thank you, Peggy. Yes, I do see a telephone icon with Anne Jordan. Anne, did you want to give your part of the presentation now? If you can hear us. You are muted, Anne, if you can hear us. maybe she can't hear us. I don't know. I do see there's a square with her name on it, but she's not unmuting herself, so. Well, Matt, did you know what Anne was going to say?
I wish I could say that I did, or that I could be as eloquent as Anne is, but I'm not going to be able to do that for you.
Okay, so maybe we'll have to go back. Peggy, maybe you can be in touch with her to see if she's still having problems or what's going on. So we'll just keep moving through our agenda, and we're up to number 4. And that actually is, I'm going to go back to my co-chair, Representative Talbot Ross.
Thank you, Madam Chair. And it looks like we just got a message from Ann Jordan to the Ledge email. I believe, Peggy, you might be able to access that. We'll see what's going on with Ann. We are going to continue, and Peggy from Office of Policy and Legal Analysis, who works with Representative Harnett on the Judiciary Committee. Many of you know her very well. We're going to allow some time for us to walk through really these definitions and what options exist in Maine. And as you can see on your agenda, what is clearing of criminal records exactly? Want to thank again Matt for his presentation, and just emphasize to get that slide deck out to our members as quickly as possible, just because it was so much information that we went through very, very quickly. I know everyone wants to do a deeper dive in it. So without further ado, Peggy, thanks.
Hi, thank you very much. And I'm not sure if I'm going to be able to talk in great detail, but if you have your binder, your resource notebook, I'm also getting a message from Ann Jordan that she's trying to unmute and join in, but she's still having technical problems. So I'll just go ahead. Tab 13 has information from the National Conference of State Legislatures about criminal record clearing terminology. And the states, unfortunately, don't use consistent terminology. And they also don't call the same records criminal records from state to state. And but so the language we were looking at. Yep.
I'm leaving in about a half hour to go get my hair cut.
So the language, the terminology we've been looking at, and what this whole binder focuses on, are different terms, and we don't use them all in Maine. One is annulment, and that is just nullifying the record. I don't know how states apply that. We do not use that term in Maine. Destruction. You'll see that some of the records, some of the state statutes actually talk about destroying records, or which I think means you don't have access. Nobody has access to them anymore. Not the courts, not criminal justice agencies, not the equivalent of our SBI. Dismissal is the termination of an action or a claim or a charge without any further action. Some states retain that information on their books, and so when they clear criminal records, that might be one of the things they clear. In Maine, we need to talk about what is public criminal history record information as opposed to confidential criminal history record information. And we can pull that up. We've actually spent time in the legislature figuring out what should be what should be public and what should be confidential, and then who has access to that confidential information. Erasure is another way of talking about making the record not available for anybody to see. Expungement, we talk about expungement, and we used to have an expungement statute before the criminal code was put into place, and it we weren't really sure what it meant anyway. It's supposed to remove the record so nobody has access to it, we think. We don't have that law on our books anymore. Sealing is to prevent access to a document or a record, especially by a court order, and to seal the record of the proceedings. So for a few years, we actually had a special sealing procedure for a very narrow category of Class E crimes. It was Class E crimes committed by somebody between the age of 18 and 21. And after the complete sentence, the complete disposition had been served, whether it was incarceration or restitution or probation, after a period of time, I think it was at least 5 years, and the person had no further convictions or charges or pending charges, they could apply to the court for an order to seal that record. And if they met the criteria, the court would seal the record, and by sealing the record, they'd send an order to Matt and say, seal this record. And it authorized the person to say, when they were asked, that they actually did not have a record of a conviction. That was kind of an experimental law in Maine. It had a sunset. The Judiciary Committee had several bills to work on that and to repeal the sunset. And we ended up carrying those over, and then we got into COVID, so it actually did sunset. It's no longer on the books. It is the subject of at least one bill that was submitted this year, and I know that Representative Talbot Ross had sponsored that bill, and she has that language and is ready to go again as the basis of a sealing process, and it is expanded from the original very narrow class of Class E crimes. So sealing usually means the record still exists, but the public does not have access to it. And each state that has a sealing process determines who would still have access to that record, even though it's sealed from general public access. I'm sorry, there is a cat sitting on my paper. There we go. A set aside, some states talk about a set aside to annul or vacate a judgment. I don't think we really look at that in Maine. And the last word is vacatur. And I believe that is actually a court action. I'm not really sure because I don't have any experience in working with that term in particular. So I'm not sure if that was really helpful in going through everything. If you've been through the binder and you've looked at the other state statutes, you'll see that there are different ways that they approach dealing with those criminal records, whether they're sealing them or what they call expunging or destroying, and also what actual criminal records they are talking about. For example, some states talk about clearing records of arrests. In Maine, if you've been arrested and there's nothing that, and there's no I believe, I hope Laura will correct me if I'm wrong here. If you've been arrested and charges don't proceed or you're not prosecuted, at the end of a year, that information is no longer public. So your arrest record, without any further convictions tied to that, is not a public record after a year. And that's not true in other states. And so if you read through those other statutes, you'll see one of the things that's being sealed or expunged or deleted is an arrest record. And I think Laura is jumping in and to correct me, or at least explain exactly when an arrest is no longer a public record. Thank you, Laura.
That's exactly right, Peggy. And one of the things that's difficult about the binder, which is just chock full of information, is that it does speak in terms of other states' terminology. And in some cases, it talks about other states sealing records or requiring a process to make things confidential when Maine already does that automatically. So there's a whole host of events in somebody's criminal history that are already considered confidential under Maine statutes without the need to go through any process. And just one example that Peggy's already given, if somebody's been charged and there is ultimately either that person is acquitted, or if there's no prosecution or no action on the case, after a year, it drops off the person's public record. So, and that's, I would offer to help Matt and Peggy and Jane come up with that vocabulary list for you, to maybe give you a shorthand of some of the definitions that already apply. I think what you'll see is that Maine already treats a lot of the things that are not convictions as confidential, meaning they don't go out to the general public. And once you have a good understanding of what's not confidential already, then maybe you want to look at the convictions and say, okay, of these convictions that are public, which of those do we want to protect? And which of those do we want to continue to make available to certain entities or agencies for certain limited purposes? For example, for the purposes of criminal justice enforcement, or for the purposes of criminal justice employment, or for child protective services. So I think once everybody has a better handle on what's already confidential, it might help us narrow what we're talking about making additionally confidential. Does that help?
And I'm happy to, if you want to look at this right now, I can pull up the Criminal History Record Information Act and share my screen and show you right now what is considered confidential criminal history record information. Would that be helpful, or do you want to just go on with the conversation?
Could I just remind us that Ann Jordan is back?
Okay, great. And actually, I know Ann has another commitment, so she has to leave by 3. So maybe if you want to switch to her and have her talk about records that the courts maintain and how the public accesses court records, that might be useful now.
Representative Talbot Ross, is that okay with you if we jump around and just let Ann squeeze in here?
Absolutely. I just wanted to put a question on the parking lot, though. And that is from what Laura just shared with us and what Peggy just shared with us. You said after a year of no conviction, if arrested, not prosecuted, it's no longer public record. My question for the parking lot is, why are we waiting a year for that to take effect? If nothing came about, we're holding somebody hostage for a year. I would like that on the parking lot, is to answer that question, why that is not an automatic. And then in the work that Peggy and Laura and Matt are going to do, the pieces Laura was talking about there's already a host of things that are already automatically confidential. If you could just include where in the process that kicks in, that would be great. And ready to move on. Thank you, Madam Chair.
All right. Thank you, Madam Chair. So Ann Jordan, are you with us? And
I am. Can you hear me?
Welcome. Yay.
No, I apologize to everyone. Good afternoon. My name is Ann Jordan. I'm the manager of criminal process and specialty dockets for the courts. A couple things I want to add based on what Matt has said. In making your considerations of these things, please keep in mind the following things. The court's criminal records have been automated electronically since 1991. Any records prior to that are 100% paper-based, and they're in thick leather-bound docket books, so it would require a hand search of a docket book to then check the docket sheet to see what an outcome was, and then a hand search either in the attics or at state archives to pull files for anything prior to 1991. a couple things that people on the committee should be aware of. Number one, civil violations, including civil adjudications, possession of marijuana, are not sent to SBI. So burning without a permit, if that's a civil violation, civil possession of marijuana, possession of alcohol by a minor, those kinds of things are not sent to SBI. Civil traffic infractions, speeding tickets, unregistered, missing your inspection sticker or an outdated inspection sticker, stop sign violations, those sorts of things are not sent to SBI. The other matters like Title 12 violations, which is your hunting, fishing, and Marine Patrol violations. The basic rule is, unless it involved the operation of some sort of motorized vehicle and it involved drugs or alcohol or a firearm, none of the Title 12 matters are sent to SBI. The Department of Inland Fisheries and Wildlife and the Department of Marine Resources have a database, but they're not sent to SBI for someone to make an inquiry about. So I just wanted that to be clear to people. The juvenile law prior to today said that Class D and E crimes, offenses that a juvenile was adjudicated of, those records, unless they were combined with a felony, also adjudication, those records were always confidential for D and Es, or the equivalent of a D or E crime. Prior to today, a juvenile record for an adjudication for an A, B, or C crime or murder was public record. The law changed today. It's much more restrictive as to what the public can and cannot get on a juvenile record. So I wanted to make, there's been some big changes on the juvenile. The court does, on those cases which are retainable, that's your criminal offenses that fall under what we can send. Those are electronically transmitted by us to SBI, and under Title 25, SBI is the official repository for criminal records. If a person does come to a clerk's window or makes an inquiry for a record at the courthouse, we can provide that. But again, most people, inquiries go through SBI because they would have to make a separate inquiry at each court location in order to get any convictions that may exist between all our different district and superior courts across the state. The court does have a records retention and destruction schedule, which is posted on the MJB website. After a certain period of time, the docket sheet is maintained, but the file papers themselves are destroyed. That's because of space and timing issues. Those are the basic things I wanted to let you know. And I'd be happy to answer any questions that may come about as a result of this. And in response to Representative Talbot Ross's question about why is it a year, that's written in the statute right now. That was a legislative decision. It wasn't a decision that either the court or SBI made.
And if I can clarify that, I wasn't super clear on that, so I'm glad you asked that question, Representative Talbot Ross. If there's an acquittal, it's going to drop off immediately. It's only those pending cases without a disposition that remain live for a year. And the purpose of that is because there's, I think there's an assumption built into that time frame that it may take that long to resolve. If it's resolved before then with something other than a conviction, it's going, and it fits within the definition of confidential criminal history, it'll drop off. But if it's still pending, it's a live case, it's an active case. Now, maybe you want to look at that year period or get some sense of how long it actually takes cases to resolve. And that's a year without any activity, a year just, sitting there. If there's more information pushed over from the court that something's happening with the case, it'll stay pending.
And the other thing that committee members should be aware of is, I'll give an example. Police Department A decides to summon someone, not arrest, but summon someone for, say, a criminal mischief charge. The file then, at that point, the court doesn't have anything because the person has been summoned. The police report goes to the district attorney's office. The district attorney's office declines prosecution. The court would not have any entry of declined prosecution in that instance because nothing had been opened at the courts. If, however, the person was arrested and then bailed by a bail commissioner for something like that, the court would have the initial bail bond, and the district attorney would then, if they decline prosecution, would notify the court they declined the prosecution, so the bail bond could be released, the funds returned, and the matter again would be considered confidential because it was a decline of prosecution by the district attorney's office.
Thank you. Further questions from committee members for Ann Jordan? So Ann, I had a question just in terms of the court, what they maintain, what they report, et cetera. Is any of that changing with electronic filing system that's coming online?
We will continue to follow whatever's in the Criminal Records History Information Act. I don't know if the Supreme Court has made a decision on whether they will be changing the records retention policy because of Odyssey.
All right, thank you. Representative Talbot Ross.
Thank you, Madam Chair. And is it possible for you to put your presentation in writing so that we can get it out to members? Because for those of us who don't work within the legal law profession, sometimes concepts and points are going fairly quickly, and it would be really helpful if we could see what you're talking about in writing, particularly the piece that you just talked about as regards to if nothing moves forward, there's no record if it's declined, those kinds of things. I also wonder if there's any way, and maybe it's already available, if there's a mapping of if it's this record, this is the pathway. If it's this record, this is the pathway. Is there any type of kind of mapping of that we could? I know we do it within the juvenile legal system, but is there any mapping that we could make ourselves available to?
I haven't done that mapping, and I'm not aware of any adult criminal mapping document that exists this time.
You can actually look at the definitions of public and confidential criminal history, and there's a list as to what's public and what's confidential. There's actually a list of all the dispositions.
Does it say, Laura, does it where in the process it becomes?
Yes, it lists the events. So after the definition of confidential criminal history, you'll see acquittal. You'll see if the grand jury decides not to indict. You'll see, so you'll see the actual events.
So,
and I'll help Peggy and Matt put that together for you with the definitions.
Thank you, Laura. Yeah, I was just gonna suggest that Peggy and Jane can probably help put that together in a readable fashion especially for the non-lawyers on the committee, or those who are not involved in the court process quite so much. So, and just because I know Ann has another commitment she needs to get to, any further questions for Ann Jordan from committee members before we lose her? All right, thank you, Ann.
Thank you. I'm sorry about the problems with Zoom.
I'm glad you finally made it. So Peggy, I don't know, had you finished your presentation, or was there more that you were going to share with the committee?
Great, thank you. I think I was going to start talking about what options are available in Maine. If you want to go forward with that.
Yes, please.
Okay, so I did talk a little bit about the kind of experimental, the pilot project ceiling program we had in Maine for that narrow category of Class E crimes. And I don't think I got into the details that the information wasn't available to the public, but it still was available to a criminal justice agency and for law enforcement employment purposes. And I just want to, even though it was sealed from the public, there were the criminal justice agency could still access that. So that means the prosecutors had it available, as did law enforcement agencies. And also if somebody was applying for employment with a criminal justice agency. The bill that was submitted in the 129th and also in the 130th was actually covering many more many more crimes that somebody could apply to have their record cleared. And it also at the same time had some additional exceptions for who could access that, and mostly in an employment context. And that bill is in your binder, and we can talk about it when you get to that point when you're actually talking about going forward with any kind of changes. But the reason that the legislature went forward with a sealing process is because Maine has a very strict separation of powers provision in the Constitution, and it's important to keep in mind that that has been interpreted as protecting the governor's pardon power. It's the governor's clemency power to pardon and to commute sentences. And so what that means is we've had some cases in the past where the law court has said, legislature, you can't do that kind of legislation because you are making either the judicial branch or you're making the Department of Corrections, you're making somebody infringe on the governor's separate, very exclusive power to pardon people or to reduce their sentences. And we look at the case of State versus Hunter in 1982, where the legislature passed a statute that allowed the Department of Corrections to petition the court to reduce a person's sentence when they were incarcerated after they'd been serving, to say that the court, please resentence this person because their post-conviction behavior has shown that they don't need to have such a long sentence. And the law court said, you are asking the court to change a sentence that's been imposed, and this person is already in execution of their sentence, and that is only the governor can do that. Only the governor has the power to reduce a sentence once it's already in execution, once the person is in the custody of the Department of Corrections, or pardon the person completely. And that has stood the test of time, and it's because our Constitution is much stricter than the federal Constitution. Article 3 of the Constitution, Section 1 says the powers of this government shall be divided into 3 distinct departments: the legislative, executive, and judicial. And no person or persons belonging to one of these departments shall exercise any of the powers properly belonging to either of the others, except as the Constitution otherwise provides. And then Article 5, Part 1st, executive power, Section 11 says the governor shall have power to remit after conviction all forfeiture and penalties, and to grant reprieves, commutations, and pardons. And although the legislature can adopt procedures to apply for those, it's really only the governor that has that power. So that has really reduced what we think, or how it's been interpreted, that the legislature can go forward with any kind of record clearing, that the fact that the court wasn't allowed to resentence somebody based on their post-conviction behavior, that's part of the governor's power. There was another case in 1985 where the legislature enacted additional good time credits that would be credited up front. And the statute clearly said, apply this to people who are already serving. They're already currently incarcerated. And the law court said, nope, they've already been sentenced. They're in execution of their sentence. By passing that statute, that is actually an encroachment on the governor's authority to pardon or commute sentences. So that could not be applied. That reduction in good time that addition of good time not be applied to anybody that had already been sentenced prior to that law going into effect. There was another bill that gave the parole board the ability to grant full discharge. Parole board, those are for crimes that were committed prior to the criminal code being adopted in 1976. So we don't have parole for any sentences since the criminal code has been adopted. But in 1986, there were people who were serving sentences under the law prior to the criminal code. There was a bill in to grant the parole board the authority to actually discharge a sentence for somebody, somebody had been sentenced to life incarceration. And if they had served at least 10 years of their term, the parole board could discharge the rest of that term. And the law court again struck that down and said, no, that's reducing a sentence and only the governor has that power. So I think that's what's been alluded to, that if you do something, if the legislature tries to take any action that is the equivalent of what the governor does through a pardon or through the commutation of a sentence, then you're treading into possibly unconstitutional separation of powers grounds. We don't know exactly where that line is. So that's why the sealing process was thought to still be consistent with that separation of powers concern, that you are not doing away with the sentence. The person has already served their sentence. All the sealing happens after a person has completed all of everything that they're supposed to do, whatever the disposition was. And so it's not infringing on the governor's power. There might be a concern that when somebody goes through a sealing process and the statute actually authorizes them to say, no, I do not have any convictions on my record, that because we're not sure, because this case has never been before the law court. But it's possible that somebody can interpret that as saying that is becoming closer and closer to being a pardon, and that you're going to run into a separation of powers concern, that only the governor can pardon. If you're saying somebody can claim they don't have a record, is that the same as claiming that they have a pardon and they don't have to disclose that? I just want to raise that as kind of a red flag going forward, that you keep that in mind, not that you dismiss that as an option going forward, but that you keep that in mind, that we don't know where that line really is between what the legislature can authorize for clearing a criminal record and when you actually step over it into violating or encroaching on the governor's power. So I guess what's important to do, and I think Laura Ustak alluded to this, is you need to think about what you're looking at. What information is there? Is it a criminal conviction? Is there more information in the criminal history that you're looking at? And what do you want to do with that? And why do you want to do that? Is it for Is it because of the collateral consequences? Is it because of employment? Is it because of housing? Is it because of immigration? So a lot of things to keep in mind as you go forward here. If you need to actually have those convictions erased and not available to anybody, then you will have to consider, I think, talking about changing the Constitution with regard to those records and the governor's power. And one thing, in State versus Hunter in 1982, the law court recognized that Colorado has a similar constitutional provision about separation of powers, how strong that is, how strict they apply it. And Colorado has started to go through a record clearing process. And they have, I believe it's, they've authorized sentencing courts to relieve collateral consequences, limiting the use of convictions in employment and licensing. And they do have a petition-based sealing of misdemeanors and some felonies, and they've just recently expanded that. So it sounds like it's very similar to what we had on the books for a little while, where it's petition-based, it's not automatic. And our law court might look to any questions in Colorado for that same kind of benefit of here's the experience that another state has gone through, having a similar constitutional structure with regard to separation of powers. So I think you need to focus on what information you're concerned about and what you want to do with that information, and why do you want to restrict accessibility to it? And that's how we can, move forward on making some progress. Are there any questions?
Madam Chair, if I may.
Yes, I think you're actually in charge at the moment, so yes.
Oh, okay. Peggy, I just wanted to make sure that the members know that the pilot project that expired, the 18 to 25-year-olds, 18 to 21, that bill, I think last session it was 1959 or 61. I know it's somewhere in this binder. But that bill that would have expanded the classification of crime, it also expanded it took away the age range. We took the age range out. It's still, I think we kept it where you still would have to apply to the courts.
Yes.
So it wasn't automatic. Yes. But I just want the members to know that bill was the recommendation of the previous Criminal Records Review Committee. That's what came out of the first attempt at this, was that proposed bill. And it's important to note because folks like Dee Clark and Ann Jordan and Matt and a number of us, Andrea and Elizabeth, Laura, we worked pretty hard to get to some place of consensus. And I really just wanted everyone to know that we reached that place of consensus with that particular bill the first time the Criminal Records Review Committee was brought together. So it's an important thing to know that we tried to accomplish something with the first attempt. The other piece I wanted to ask is to Peggy around the Colorado reference. Is that any part of the Colorado work that you just referenced? Does any of that include an automatic process, or is it still one in which you would have to apply?
Right. My understanding is Colorado is still a petition-based system. And I don't know if that issue plays into the separation of powers. I mean, that's a process thing as opposed to a substantive law thing, I think.
Okay.
And LD 1459 is on page 31. It's behind tab 2, page 31 of your binder. The bill that Representative Talbot Ross was just referencing.
So much for my recollection of LD numbers, but 1459. And then just for the parking lot, as we try to figure out our next steps, it occurs to me that one of those subcommittees or part of some work needs to happen around exactly what you're talking about, Peggy, and what Senator Bailey and I referenced early on, which is a proposed constitutional amendment that would clear up all of this gray matter on where is the line between the legislature, which has taken action all the way back to the 1980s to make a clear pathway for expungement or vacature and or permanently sealing versus the powers of the executive branch, executive officer, the governor. So I would like to just put that as one of the pieces that I find most interesting about this process is to delve into that line. Thanks.
So,
yeah, thank you. I want to find out others being brought into this conversation. I know that it's a lot of information in the last almost 2 hours, but getting other voices into this so that we can make some decisions about how to move forward is going to be really important. Any comments or questions for all of we still have everyone who has presented today still in this Zoom. I see Ann is still here for the next 5 minutes.
So Representative Ross, I would just point out that I saw, and I don't know.
Representative Harnett.
She's under Robert W. Has her hand up.
I'm sorry, it's Marianne Lynch under Robert W. I'm using a different phone.
So we'll go to Marianne, and then I see Representative Harnett has his hand up. We'll just do both of those back to back. Thank you.
So I just wanted to reinforce my experience with that temporary legislation we talked about. And I think in looking towards it, I know I've told you this before, Penobscot County, I think, did more of them than any other county in the state. We were very impressed with the way it ran. The stories I thought were pretty compelling. You know, people who had shoplifting convictions at 18 and then coming in at 21 because they had, you know, really achieved some other bank responsibilities. And I agree with you. I think that was a good framework to begin with. There was a lot of meeting in the middle about it. I observed from, my standpoint, even though the district attorney didn't have a lot to do with it, they were typically scheduled when we were in court. And I'm thankful that you referred to that because I just think that it's, a show we could work together on it. It was temporary. And I just want to say it worked really well, even though, and I don't know why other counties didn't do as many as we did in Penobscot, but it worked really well here.
Thank you for that. And for those who are trying to keep up, that what the district attorney is talking about is under the old pilot that only had a 3-year window on it. Penobscot County processed more requests for that information to be removed than any other county. So we thank you for pointing that out. Yeah. Representative Harnett.
Thank you, Chair Talbot Ross. Really 2 questions. One is a historical question. Has there ever been a serious effort to amend the Constitution to address this issue? And 2, was there a challenge to the program that recently sunset? Was there ever a legal challenge regarding whether or not it violated the Constitution?
Peggy, would you like to take that?
I can take it and tell you that I don't think that there was ever an effort to amend the Constitution that actually went forward to the voters. But I haven't researched that directly. I just don't remember seeing it in all the questions that have gone to the voters over the years. And as far as I know, I don't know that that sealing process was ever challenged. I don't know that we've ever asked for, you know, a survey of people who went through it to see if it was successful for them, and maybe they don't want to come forward since their records have been sealed. I don't know of any court challenge to it, and maybe I don't know if Ann Jordan might have some more information about that, because it would have had to go to the courts about it. But so I think it seemed like it was working, and the legislature was going to expand it, and then that, you know, COVID and everything else happened. So
Ann,
Thank you.
thank you, Peggy. Ann, you want to quickly respond to that before you leave?
I have 2 minutes before I have to leave. I can say I know of no challenges, constitutional challenges brought by others, because it was a sealing process, not an expungement or a commutation process. The number of petitions that were filed, we ran those numbers. I can't recall exactly off the top of my head what they were, but if it was somewhere less than 50 statewide over the 3 years. We ran it before, and I can dig it up, and I'll offer to do that for the committee. But the numbers were very, very small, the people who actually filed petitions. We found that same thing with, there's a provision in the juvenile code that allows for the sealing of felony records. And we found that same, running what we had off our computerized records, very, very few petitions to seal those as well.
And Ann, before you leave, I mean, I just should note, I think it was 50 that you presented last time as well. But one of the things DA Lynch had pointed out, and a number of others, is how very little information the public had in order to then request for the sealing. That the 50 wasn't representative of only 50 people needed it. It may be representative of nobody knew that they could even do it. And most importantly, the process really was not, you'd have to really be committed to it in order to put forth that request to the courts. So there's a number of things that go around the narrative for the 50 has to be considered.
We had a form, because I worked with former Chief Judge Laverty on it. We had a standardized petition form available to members of the public in order to provide the provisions for that. I'm just saying it wasn't used much. We did not do a survey, so I can't tell you, was it because the public didn't know about it, defense counsel weren't telling people, was it a combination of the things? We just don't know why the numbers were as low as they were. There was no survey or way to determine statistically why that was.
And Ann, before you leave, just for the record, was there a cost involved? I just want the public to understand this whole thing. So I'm asking a rhetorical question,
No,
but was there, thank you.
I'm sorry.
No cost involved.
There was no petition cost. Just as we don't charge the prosecutors to file a criminal complaint, there was no petition cost to file that kind of request.
Yeah, thank you. Thank you very, very much. I know you have to go, but
I'm sorry, I gotta
hope
go.
We will see you at our next meetings, because I know you're, hopefully you'll be back.
If you want me, I'm not a member of the committee, but.
We want you, we want you.
Okay. Thank you. Bye-bye.
Thank you. Yes, Madam Chair, Senator Bailey.
Yes. So any other questions for Peggy before we move on? All right. And so my question now would be for Jane, and whether you are prepared to go through the resource book.
Sure.
Yeah, you have
Yes.
your issues
Yeah.
resolved or whatever. So, because I think that we had that left over. So if you want to do that, that would be wonderful and very helpful. Thank you.
Okay. I'm just sharing the screen, and this is the resource book that we mailed out. I think on Friday the 8th, we mailed those out to people who were far away or not coming to Augusta. And we also sent some by the state mail. I think I heard from Matt that his had not arrived. So even though it was right here in Augusta and it was in the state mail, it didn't get there. So if yours doesn't come and you're expecting one in the next couple of days, give me a call or Peggy or drop us an email and let us know, and we'll begin a search for it. But it is available on the committee's webpage. In case you didn't know, the Criminal Records Review Committee has its own webpage. It is under legislative offices, under the Office of Policy and Legal Analysis, then under current studies, and the study has its own webpage. It has membership information. Has been, I was waiting for final confirmation of the last member, hopefully to get that today, but the rest of the information is there. And this is the table of contents of the handbook. The handbook is posted, and over here you'll see I'm moving my mouse to the left. There are tabs that correspond to all of the tabs in the handbook, so you can take a look down. You can see the main fair chance employment, which is about the use of the box. Then there are a number of different articles or compilations of different state laws. Most of these are from a National Conference of State Legislatures or the Collateral Consequences Resource Center, and which we provided information on those two entities at the end of the book under related information, which you'll see down at the bottom. The under related information, the glossary is also there. We have tried to keep those compilations of laws up to date, and we're actually still just about to send out to you a new compilation that we've done here in the office. You'll also see compilations, they're information from other states: California, Connecticut, Michigan, New Jersey, North Carolina, Pennsylvania, Utah, and Virginia all had laws that look like it might be helpful to you to have more specific information on those. So we put those in here. I would say that the terms that we use will become more and more important. We went through the glossary on, the difference between expungement and sealing, and some of the things that are written about the collateral consequences legislation are mix up some of the terms. In addition, things like what's a misdemeanor are different in different states. So the language may talk about misdemeanors, but if you really get down to an analysis of it, you'll see that some misdemeanors in some of these states carry jail terms of 2.5, 3.5, 5 years. So it'll be important as you decide what you want to be specific about exactly what you want, so we can help you get there. That's all I have on this. If there's anything I can help you with, please don't hesitate. Okay.
All right. Thank you, Jane. Any questions from committee members about the resource book and what's in there?
Madam Chair, I just had a quick question. And that is, since we've been talking about the governor's powers and the state's constitution, I'm just wondering if we can get that added to our resources, is to look at that section of the Constitution that talks about the powers for to pardon and remit penalties, et cetera, and conditions.
Yes, and I know Peggy has that already, and we'll get it out to you.
Okay, I appreciate that. Thank you.
All right, Judy Meyer.
Jane, this book is amazing. I'm wondering if it's available digitally, which is so much more portable, if it could be shared that way as well.
I'll check.
Okay, thank
Yeah.
you.
You mean, what do you mean? You mean there's an
The electronic
copy.
version. Yep.
There is an electronic copy on the committee materials section of the webpage.
Okay.
That
That will
is-
stay up to date as we're discussing.
Oh. We'll keep posting materials that we send to you. Is
Okay.
that what you mean?
Yes.
Yes, we will.
Okay, thank you.
So right now, this is posted under today's date. If you go to the webpage, and can I share that real quick? I don't think I can share it. Yes, I can. So this is the webpage for today. And there's a meeting agenda, and then there's also the resource notebook. So if you go to, this is a Criminal Records Review Committee webpage. It's very easy, legislature.maine.gov/criminal-records-review-committee. That should get you there. And here's information about the meetings going forward and the YouTube links. When we get the final list, we'll post the committee members list. And for each meeting, the materials will be posted on the link. So right now, the resource notebook is only posted for the first meeting. We can also post that further down so it's available, and then we'll have updates that we will post as well. If that makes sense.
Did you have a follow-up, Judy, or is that your hand from before? And I think I saw Courtney Allen's hand.
I was just going to ask for the link, but she told us. Thank you.
Okay, thank you.
I'd like to chime in and just say thank you. That's tedious, hard work. And I appreciate how simple you made it for me. Thank you.
Yes, Peggy and Jane did an incredible job, so I extend my thanks as well.
Well, and we also, just real quick, we want to shout out to Darlene Shores Lynch in our office, who actually did the prototype of this and put it together, and then our whole support staff that copied all the notebooks and wrapped them up and mailed them to you. And I'm sorry that they aren't all in your possession yet.
Thank you, and thank you to the staff, absolutely. And Representative Talbot Ross.
Thank you, Madam Chair. One thing occurred to me is when I think about this fair chance legislation, thank you for including it. But I'm wondering if we are able to put in information on pending legislation that will impact this work, because there is a fair chance bill in on housing that is currently, well, there was a fair chance housing bill that was passed that is a resolve, and it directs Maine State Housing Authority to assemble stakeholders from public and private housing to look at what a ban the box effort would be on housing. So I'd like to add that fair chance legislation on housing, even though it's a resolve that we're direct, and to look at some of the upcoming bills, should they get past Ledge Council, that may also have some impact in this area, if that's possible.
Certainly, we can I think the council meets next Monday on first run of the bill, so we can update you that, whatever goes forward.
All right. Further questions for this section of our agenda? Just taking a quick look. Not seeing any. So I think we're up to the last part in planning for upcoming meetings. And in particular, I think we need to further talk about subcommittees and what those might look like if people want to set those up. And I think Representative Talbot Ross and I did want to talk about the fact that the next meetings are all set up as hybrid meetings because, and I'll just explain why, but I think we did want to just get some input from the committee on that model. Our thinking was that as we go forward and we really need to engage in discussion, that is difficult to do just by Zoom. But at the same time, realizing with 29 members that all people won't be able to make it physically to Augusta, and to give them that Zoom option. But hoping that many members will be in the room so that we can have our discussions. So I would just throw that out to committee members and just see if there's any strong objection to that model going forward. So I'm not seeing anything. I don't know if it's just because it's late in the day and people are falling asleep, but if you, D. Clark. Oh, you're muted, D.
Thank you. I'm sure my meetings will be Zoom. However, Mondays are a very bad day for me. I have a standing meeting paid for that I do every Monday morning. So missing one here and there, but this will make it difficult.
Yeah,
and I'm left with a hard choice.
Yeah, and I do apologize for that. I mean, these meetings will be in the afternoon. And I have to say, again, with 29 members, we did make a conscious decision that we won't be able to accommodate everyone's schedule. It's just impossible with 29 very busy people. That's another reason why we wanted to do the hybrid, because at least, some people who can't make it physically can at least listen in by Zoom or see the results, the recording, and review it and review the committee materials and participate that way. Any other thoughts just on the committee meeting model going forward? Representative Talbot Ross.
I just wanted to emphasize for Dee, all of our meetings are from 1 to 4 in the afternoon. So you may not see it because it's at the end of the agenda today, but hopefully that will alleviate a little bit because you have an absolute critical voice in this process. And you've been hanging in there for about 4 years, I think, 3 or 4 years on it. So I just wanted to point out it's in the afternoon. And those who feel safe enough to come to the State House will join us. Thank you, Madam Chair.
Thank you. All right. So I think we're all set on at least the format. So I think the other thing I wanted to discuss is the idea of subcommittees. And again, whether people feel that would be helpful to kind of do a deeper dive and then report back to the committee. If so, what subcommittees do you think we should form? I heard 2 possible suggestions. One is legislation, pending proposed recommendations for legislation. And then the other idea I heard was exploration of possibly proposing a constitutional amendment. So I guess my first question is, are there other ideas that people have that they feel would be helpful, necessary, informative to this committee in our process as far as forming a subcommittee besides those two I just mentioned? Okay, I'm not seeing any. If you do have those, certainly get those to the chairs and or legislative staff as soon as possible. So of those two subcommittees, I guess I would first ask if there's any persons who are interested in chairing either of those subcommittees. Let's start there. I'm not seeing any volunteers. Are you going to make me appoint people? Representative Harnett, I did hear you ask about the constitutional amendment. Would you be interested in chairing that subcommittee?
I am very interested in the constitutional amendment issue. I worry with responsibilities on other committees that I'm chairing, but if and this is always dangerous to say, I don't know if this is an appointment or a request, but if it's necessary, I would be happy to bring that group together. But I would not be at all upset if there was someone else who wanted to take that on.
Thank you. Is there anyone else who is interested in chairing the constitutional amendment subcommittee? And let me just say, that doesn't mean you support it or don't support it, or it's just to explore that issue. As you heard Peggy explain, it is part of the mix. And again, I think it does require a deeper dive, and to be able to come back to the committee and report, well, these are kind of the options. And one of those options, of course, can be do nothing. So I don't want you to feel that just by chairing this subcommittee that you're, indicating support or lack thereof at this time.
Madam Chair, if understand that everyone's plate's full, but if no one does come forward, I will work with Representative Harnett on this. This is an issue for me that is absolutely paramount because of the years of legislation. And we had a good history lesson, but dating back to 1982. But in the most recent legislative sessions, this comes up each and every time. Each and every time it is it's the interpretation of the expansion of the governor's powers. And it's been pointed out to me by Senator Hickman in talking about this between the two of us, that it says that the governor has powers. It doesn't say the governor has sole power. So this is a really, really important piece that I think unlocks a lot of the sealing versus confidential versus this versus expungement. So Representative Harnett, I'd be glad to lend assistance to you in any way possible and try to move this particular subcommittee forward.
Okay.
I appreciate that. And I think it's obviously it's an issue that we have to resolve either with taking a new look at the 1982 Hunter case or seeing if the amendment is what's necessary to make this committee do the work that it wants to do. So happy to work.
All right. So why don't we make Representative Talbot Ross and Representative Harnett co-chairs, and so you can share those responsibilities. And so if folks are interested in serving on that subcommittee, would you like them to communicate with you directly or to go through Jane and Peggy? And I'm asking Representative Talbot Ross and Representative Harnett.
I would love the services of our able staff to help with communication.
All right. So if folks are interested in serving on the Constitutional Amendment Subcommittee, please contact Jane and Peggy, and they will pass your information on to Representative Talbot Ross and Representative Harnett. Thank you. All right, so the other subcommittee would be legislation, proposed, future, recommended, etc. And again, is there someone who is interested in chairing that subcommittee? Judy Meyer, you had a question?
I do. The legislation, or the resolve, should I say, has 9 specific tasks for us to do, and most of them are legislative, which is really quite a to-do list. Would we have the option of selecting among the 9 to pare it down, or are all 9 a must-have?
I think the committee can do whatever it chooses. I mean, I think that. Well, for a 61-year-old female, she fell. I'm not sure who that is, but.
Oh, sorry, it's my scanner.
Oh, it's you. Okay. Thank you. Actually, I'm looking at this and it does say that the review committee shall, and then it does list 9. So I'm not sure how optional it is, but it's certainly, in terms of how deep we dive into each issue, is going to be somewhat geared.
Well, I'm interested in that work, and I'd be happy to co-chair or chair if no other volunteers spring forward.
In the legislative committee?
Yes.
Okay, thank you. Is there anyone else who would care to co-chair that with Judy? I'm just looking.
I just had a process question, if that's
Yes.
all right. I was wondering if there would be any value to further breaking down into other subcommittees. Maybe not necessarily 9, but grouping together some of the duties. Oh, sorry.
Sure.
Yeah, I agree.
Okay. Yeah, I mean, I had asked about if there was interest in other subcommittees, so I think that's certainly worth exploring. Absolutely.
I mean, one such subcommittee could be looking at, it's in section 5, and it's number 3, which is convictions for conduct that's been decriminalized, convictions for victims, survivors of sexual exploitation, sex trafficking. I just think there are convictions that we hold out as exceptions, including what we did in LD 1459. So I'm just wondering if there's a specific emphasis around, even with all of the work that we do, if we want to pull out those, do a deeper dive on things that have been decriminalized and things that are conduct committed within a sexual exploitation, sex trafficking, if we want to pull those out, the exception clauses.
Yeah, so the number 3 in the list of duties. So that could be another subcommittee. Emma, did you have any of the listed items in particular in mind for a subcommittee?
I didn't necessarily, although I guess just thinking on the spot, there is number 7, which says invite comments and suggestions. And so does number 5. I don't know if that is considered what we're doing here in this committee by having this broad group, or whether that was an additional task that needs to be taken on.
Actually, that was next on my list, was to talk about future presentations.
Oh, okay.
That's what I call those, bring
Okay.
interested parties and, what other interested parties would people like to hear from and presentations. Yeah. And I would say, a lot of these, no matter what subcommittee you're on, you're probably going to talk about a lot of these listed items. But certainly as Representative Talbot Ross indicated, I'll call it the exceptions subcommittee, in particular, number 3, may be something that requires a little deeper dive. So do I have volunteers to be chair and or co-chairs for the exceptions subcommittee? Representative Pickett.
Yes, thank you, Madam Chair. I just want to let you know the only reason I have not volunteered to take on a chair or co-chair position is I have 3. My wife has 2 elderly parents right now that we're dealing with, trying to get things done with DHHS to get them into long-term care and stuff. And anybody who knows that process knows it's very deep, and I don't certainly want to leave her alone doing that. I've been working on those now for about 6 weeks, and it looks like it's going to take some time. So that's the only reason. Other than that, I would have done that. I just want to let people know that.
Thank you for sharing, Representative Pickett. And yes, that is a lot of time and emotional energy. So I can appreciate that.
Well, I'm sorry to say, I'm still in the dust. I hear section 5, number 3, and I go to it and I don't hear any of the words that are coming out of the person's mouth. I don't see that on the pages.
Okay. So,
and I hear someone say section 7, and I don't hear any of the words that I see on the page.
Okay. So Dee, do you need me to read when I'm saying the exceptions subcommittee? Do you need me to read that section 3 so that you understand what I'm referring to? Is that
not necessarily? I just need any reference to a tab or page to match. So make a reference.
okay? So we're looking at, this is under tab 1, and it is page 3, and that lists the duties of the committee. That's what we're talking about right now when we're talking about numbers. It lists duties 1 through 9. Representative Talbot Ross, did you want to?
Yeah, and so if I may, Madam Chair, Dee, thank you for making that exceptional point, because it is hard to keep up with so much material. What I was suggesting, Dee, just to recap really quickly, is on page 3 in section 1 of the bill, under 3A and B, that we pull that out and create a separate subcommittee, just looking at the exceptions component to most criminal records reform I've been a part of for the last 5 years has always had reform with these exceptions. And I think this is I'm suggesting we pull that out and create a separate subcommittee. But it gives me an opportunity to just to acknowledge Jill Ward, who's with us, who was one of the principal architects for the bill that passed this session. I think Ann Jordan referenced that it was state law as of today. The changes that we made in the juvenile criminal legal system around records. And I think that if I may, Madam Chair, I'll just ask the staff if we could get that information for this committee, because the work that was done on that particular bill that is reforming records, accessibility to records, dissemination of records within our juvenile system is remarkable. And Jill was one of the primary architects for that work. Thank you.
Thank you, Representative Talbot Ross. Jill?
Yeah, if I might, thank you so much for that. We did just also do a training, which I think several on this committee may have attended, around changes to the juvenile code generally. We did a whole section, and the we being the center with the Maine prosecutors and the State Juvenile Justice Advisory Group. We did a whole section for practitioners on the changes to the records part of the code, and we did a rubric that was described earlier about when things are confidential versus not confidential. And so I would be happy to share that package of materials that are relevant to this for context on the changes we made around juvenile records for everybody's information. And that training too, we're going to try to make that accessible to others, but at least the materials I'm happy to forward along.
Thank you. Thank you, Jill. So again, just looking to set up this exceptions subcommittee. Anyone interested in hearing that? Elizabeth?
Yeah, I'm just trying to understand the exceptions subcommittee. So we are talking about section 5 of the bill, number 3, is that right? Okay, so this is about the things that are no longer criminal and how to deal with those.
It's 3A and B.
Yeah. Okay. All right.
Yeah.
I just want to be clear. Something about the conversation got confusing to me. Okay.
Right.
Gotcha. Thank you.
So B, I would think, would be of particular interest to your organization and similar organizations. But yes, it's 3A and B. So Elizabeth, are you volunteering to be a co-chair? No. Okay.
No, with all due respect, I'm a terrible chair.
Okay.
Facilitating and chairing things is not my bag. And I'd be happy to provide a number of references that will attest to that being the case. I am not a linear thinker. I am not organized in my thinking, and people just follow me around on a path like this, and it's no good. It's just real bad. But I'd be happy to participate in the conversation.
Great. Thank you.
You know,
Yeah.
Madam Chair, I was just going to make that suggestion. We've got 27 other extraordinarily busy people. I'm wondering if we create the subcommittees and let folks navigate to those subcommittees through Peggy and Jane, and
Right.
then amongst themselves, they figure out who might be able to take the lead in communicating their work to the full committee, if that might be an easier ask for our 27 fellow very busy Mainers.
No, I think that's a great suggestion. So we'll just leave it that, again, those are the 3 subcommittees. People can contact Jane and Peggy, which ones you would like to serve on, and people can choose their own chair or co-chair or do it however they want. So thank you for that. That makes perfect sense. So as I indicated in response to a question from Emma, I do want to have a discussion about what committee members would like to see for future presentations or information as we get going forward here. And Peggy and Jane, I'm sure, will do their best to match up speakers and presenters with your interest. I see Peter with his hand up.
Being foolish till the end. Number 6 in our charges seems to me to be tremendously important. Review existing information about the harms and benefits of making criminal records confidential, including the use and dissemination of those records. Interestingly enough, I take as the corollary of this that we should look for evidence for the harms and benefits of making criminal records public. I have found, quite frankly, as a sociologist, no credible evidence to support the effectiveness in reducing victimization of making this criminal records public. And a good deal, well, some evidence, good deal is too strong, but some evidence that it increases victimization to make them public. I would like a presentation at the very least from somebody about what the empirical literature is. The only positive empirical literature I can find is literature evaluating the effects of clean slate, which have suggested that making records confidential decreases victimization. I think my goal in a lot of this is to decrease victimization. It's just not clear to me that our assumptions about what decreases victimization are correct. As Senator Bailey said in relation to the purposes, if the purpose is to shame or further punish, then it seems to me that that is easily counterproductive if what we're trying to do is to promote safety.
Thank you. So Peggy and Jane, do you think is that enough information for you to do some looking to see who you might be able to line up to get us some information on kind of the harms and benefits of public versus confidential criminal records?
Maybe somebody who speaks French, where records are all confidential and victimization is lower.
So I'm happy to say that we can look into that. If we can't actually get a presentation, maybe we can kind of summarize whatever evaluations and literature there is out there about that topic.
Thank you. Representative Pickett.
Yes, thank you, Madam Chair. I was just looking through those duties more completely. And number 5, inviting comments and suggestions from interested parties, including but not limited to victim advocates and prison and correctional reform organizations. Do we have, are we thinking down the road having a presentation by that group of people? I think that would be very helpful.
Okay. I think we can do that. Peggy and Jane. Okay. So one thing that occurred to me as we were hearing, in particular Peggy today, is I would like more information about Colorado and kind of their path, if you will, and where they've been and where they are, especially since they are similar in terms of our Constitution. And so it seems like they have gone down the sealing route. And so I would love to hear more in depth about the Colorado experience, if you will. Love to hear from someone from Colorado, if that's possible, maybe via Zoom, obviously. But Peggy and Jane, if you could look at what we might be able to line up for that. Elizabeth.
Just following up on Representative Pickett's question/suggestion, it dawns on me that our organization is one of those that might be considered under that victim advocates group. And I think from my perspective, we're going to be considering a whole lot of different kinds of things. And I think the way that we considered, at least as our organization, moving forward with this group is to provide ongoing, thoughts as we go along. I don't know that we were thinking about having victim, organizations present, but at this time, we don't feel like that would necessarily be a good use of your time. But I think we well enough to know that we'll be providing feedback on an ongoing basis as we work out, work through the various sections that we're thinking about. I know I'm clearly not speaking for Survivor Speak or for for MCEB, who are, I know are the organizations that fit into that category, but just speaking on our behalf.
And thank you. And yes, I think the reason that you and those others are on this committee is so that you will speak up and your voices will be heard and considered. Absolutely. Oops. Sorry. Emma, did you have your hand raised? Yes.
Yes, I did. I guess I was curious to learn more about states that made the decision to enact automatic sealing as opposed to petition-based. And I mean, I guess I was curious too about the history here in Maine and how we came to try something at first that was petition-based, and maybe it was just how, you know, the administrative difficulty is much less. I don't know. But I'd be curious to hear from someone perhaps from Michigan or one of the other states that have embarked on that route and how it's going. And I don't know who the person would be, maybe the architect of that bill in Michigan or another state that's tried that.
All right, thank you.
Madam Chair, if I may reply to Emma.
Yes.
Yeah, I think we would be remiss if we didn't try to invite someone from the Center for American Progress. They've done an enormous amount of work on what you're talking about, Emma. A lot of it is called clean slate legislation, which has an automatic component to it, and it wipes out, depending on classification of crime and length, no further activity. So, and then there's folks that helped get through the Pennsylvania clean slate legislation specifically. So maybe the Center for American Progress, and then the folks in Pennsylvania who marshaled through clean slate legislation there. And I can help figure out who those folks are, Peggy and Jane, if you'd like. But I think that's number 2, actually, in the section 5 duties on page 3 in tab 1. Number 2 is consider clean slate legislation options. So we could put that all together, Emma, if that makes sense. And then my suggestion is, I don't know if John Feeney, I think John Feeney is here still with us, but I do think whether it's a presentation or if it's just material that he brings forth, I think he had offered to do so. I wanted to highlight that. There really is a separate way, a separate consideration for Child Protective Services. What's going on in the state around children's well-being is not lost on anyone. And I think that we need to be particularly responsible to understanding the ways that Child Protective Services and all things that revolve around that are considered by this committee.
Thank you.
Thank you.
Well, I think Peggy and Jane have lots of homework, but I'm sure they'll find all kinds of speakers to help us. Jill, did you have a question or a comment?
Yeah, just a quick question, and I apologize that I have not thoroughly gone through the notebook, but the Clean Slate Clearinghouse website, is that a resource that has been lifted up for everybody? I see Representative Talbot Ross is nodding, because it does do state by state comparisons on Clean Slate and fair employment. And so I was just looking quickly for reference. So I apologize if I'm wasting everyone's time and it's in the notebook, but it's a website that the Departments of Justice and the National League of Cities, I think, it's a collaborative government and nonprofit resource on this issue.
Thank you. Samantha?
Yeah, and there have been some great thoughts shared today, but I just want to make sure that we are also considering how the public is able to access records moving forward when we think about taking away some of those rights. And quite frankly, it's journalists quite often that are going to police stations or monitoring police logs or going to courthouses. And there are plenty of people that are arrested or come in contact with our criminal justice system that we're not going to write about and that are not going to show up in any kind of newspaper or on a daily news segment. But for the people that are, I think that we have to preserve some ability for the public to become informed, because it's not just journalists being inherently curious about these things, but they're informing their communities. And so many of you consume news on a daily basis. So if the government is making a decision to charge someone, your public and your community has a right to understand what that is, and then to go back a decade and look at trends. Did laws that we implement really affect the outcome for the individual person? And the only way we can do that is if we have access to data and to records. So I would strongly suggest that we bring someone either from the Society of Professional Journalists or the Reporters Committee for the Freedom of the Press to provide some kind of context for you guys, that we're thinking about how this is going to have an impact on all the journalists that are also functioning in this state, and trying to provide a level of accountability and transparency and how that will be changed. So that would be my suggestion. Those are two great organizations. You also have an amazing resource, Sig Schutz at Pretty Flaherty. Those are public record laws. And I just don't want that to be lost in all of this.
All right. Thank you, Samantha. Not seeing any other hands. So again, I think we have a pretty good path forward in terms of future presentations. And we're just about at 4 o'clock. So are there any other questions, concerns that committee members have before we adjourn? Our next meeting will be, looks like Monday, November 8th. That will be hybrid. So those of you who can make it will be in the Appropriations Committee room 228. But it will also be available for people to participate by Zoom. And we'll be working on an agenda. Of course, a lot of that will be driven by who Peggy and Jane find for presenters or information that you've requested in their availability. So we'll obviously try to get some people available for November 8th, but that's to be determined. And yeah.
Madam Chair,
Yes.
I'm just, thank you. I just want to make an explicit request a little bit clearer. I heard Jill Ward say that she would share with us some of the changes to the code that take effect today via training and presentations that have taken place at JJAG. I'm wondering if we can ask you, Jill, if you would also make available kind of that roadmap that happens for what happens with, I know we're going to get it for the adult system, criminal legal system. I'm wondering if you can provide that roadmap so we can see what happens to our young folks who are caught in the system. If
The chart, yeah, yes, absolutely, yep. Like when the review is triggered, what's automatically confidential, what's not automatically, who gets to petition to have it be made open or to have it be made closed. Yes, that chart will be in the material.
Yeah, and those age ranges too, I think.
Yep.
Yeah,
Yes.
okay, that would be
Absolutely.
great. Thank you. That's the
I
only.
know exactly what you're talking about, and that will be in the material.
Thank you.
You're welcome.
Thank you, Jill. Peggy, what did you have for us?
I just wanted to add a couple logistics about the hybrid meeting that I believe the Legislative Council will still have in place the policy that anybody who's going to be in the building do the self-screening for COVID, and also they'll be required to wear masks in the building, or at least in the room.
Correct. Thank you. And Peggy or Jane, is there anything else you need from us at this time? Is there anything we forgot? No? All right, well, if there's nothing further, I would entertain a motion to adjourn.
So moved.
Second. Moved by Representative Pickett and I don't know who seconded it. Senator Rosen, thank you. All those in favor of adjourning? All right. Thank
Thank
you
you,
all.
everyone.
Thank you all very much.
Bye, drive safe. Take care
Thank
till
you.
next time. Bye-bye.
Bye.
Thank you.